Disability laws that apply to higher education. There are 3 laws that govern disability services in higher education. What one law doesn't cover, another law does. Americans with Disability Act, often referred to as ADA, was passed in 1990 and amended in 2008. Ensures access to facilities, services, and programs. Section 504 and 508 of the Rehabilitation Act of 1973 provides for reasonable accommodation and covers any institution receiving federal funds. Our state has the Washington Core Services Bill. This law requires ongoing review and a clear grievance procedure. It also outlines reasonable accommodations and lists core services. Disability laws in higher education are first civil rights laws. They differ from Individuals with Disabilities Education Act, IDEA, that applies to the K-12 system. Focus is on access rather than success. They do not exempt students with disabilities from meeting the essential requirements of a course or program. Implications of the laws. Students otherwise qualified have a right to enroll. Once admitted, students have a right to access academic and non-academic programs. Qualified students are eligible to receive accommodations that relate to their disability. Failure to meet the legal obligations of the law can have significant implications for post-secondary institutions and the people involved in providing educational services. The definition of a disability. A person is considered to have a disability if one of the 3 conditions is met. The person has a physical or mental condition that causes functional limitations that substantially limits one or more major life activities, including mobility, communication, such as hearing, seeing, and speaking, and learning. The person has a record of such an impairment. The person is regarded as having such an impairment. For more details about these specific laws, refer to the links provided in this module. Dispute resolution is another part of the law. Students are encouraged to resolve concerns by first contacting the coordinator of disability support services. If a student is not satisfied with the resolution, they are directed to the Walla Walla Community College grievance procedure. The grievance procedure has three steps. Step 1, informal meeting to resolve concern. Step 2, official hearing conducted by the 504 compliance officer. And Step 3, presidential appeal. Please note that during this process, the student is granted protection from retaliation. All proceedings are confidential. At any time, the individual may file a complaint with the Office of Civil Rights. For more information, refer to the Walla Walla Community College written procedure for the resolution of discrimination and sexual harassment complaints included in this module.